Hello, everyone. Welcome to Assembly Judiciary. Sorry about the delay today. We are going to let me start with this. So we're having a few little technical difficulties. So with that, I'll get to that in a moment. But first, welcome to Assembly Judiciary. Those of you that are here in Carson City, and of course, anyone watching online. With that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Here. Assemblywoman Cohen. Here. Assemblywoman Considine. Assemblywoman Gallant. Here. Assemblyman Gray. Here. Assemblywoman Hanson. Here. Assemblywoman Hardy. Here. Assemblywoman LaRue Hatch. Here. Assemblywoman Marzola. Here. Assemblywoman Mosca. Here. Assemblywoman Newby. Assemblyman Orentlicker. Here. Assemblywoman Summers Armstrong. Assemblyman Urick. Chair Miller.
Here. And I believe, yes, all members are here. So with that, just a few reminders. We ask that you, when you're planning on presenting, that you make sure you get your materials in at least by 12 noon the day prior to your scheduled hearing. Also asking that everyone turn down any of their electronic devices or anything like that that could be disruptive. We will have public comment at the end of today's hearing. We do have two bills that we will hear today. We're taking the agenda a little out of order. And both presentations will occur. Our primary sponsors are actually in Grant Sawyer or on Zoom today. So we will open with Assembly Bill 405. So Assembly Bill 405, presented by Judge Nadia Wood, revises provisions relating to court programs for the treatment of mental illness or intellectual disabilities. Judge, do you have anyone here in Carson City that's participating with you, that's presenting with you?
Good morning, Chair Miller. I do not.
Okay, so with that then, Judge, your hearing is open and please proceed when you are ready.
Thank you. Thank you very much. I'd like to start by thanking the chair, thanking the Assembly Judiciary Committee for allowing me to present this bill. So AB 405 aims to expand mental health treatment in the state of Nevada. The purpose of this bill is to clarify that Justice Court has jurisdiction to establish a mental health court program and clarify that any individual who is granted probation by a sentencing court can also receive mental health treatment regardless of their underlying crime. And finally, to clarify that mental health courts have the authority to impose intermediary sanctions, including incarceration, consistent with clinical recommendations. So I'd just like to start by briefly talking about the cost of not treating mental health here in the state of Nevada. In 2021, Clark County spent $286,998,563 to incarcerate 2,854 individuals in the Clark County Detention Center. Approximately 20% of the inmate population at the Clark County Detention Center is estimated to be medicated for mental health issues. So why do we need this bill? The Las Vegas Justice Court, which is currently the largest justice court in the state of Nevada with 16 justices apiece, is seeking to create a mental health court. Before moving forward with the creation of a mental health court, we're seeking cleanup language to clarify our jurisdiction to create such a court. The proposed language that we have in this bill the reason that we need a mental health court now, the reason that we need a mental health court now is, I apologize. I think I slipped a step. There we go. Thank you. I'm sorry. The current statute, currently NRS 176A.250, allows the court to establish a mental health court program. That is the statutory authority for mental health court programs in the state of Nevada. However, NRS 176.030 defines court as the district court. So as the language currently is, while it allows courts to establish mental health court, we've got another statute that potentially limits that definition of court to only district courts, not justice courts or municipal courts. NRS 176A.250 does reference NRS 174.032, which allows justice court to establish programs. So based upon that reference, it does appear that it was the intent of the legislature to allow justice courts to establish mental health court. However, as currently written, because it used the word court and the word court is defined by our NRS as meaning the district court, the statute could be interpreted not to grant jurisdiction. This creates a problem for us, going back to the fact that we want to establish a mental health court in the justice court, but our concern is that if we establish the mental health court and then it's determined that we don't have jurisdiction, we'd have to stop in the middle of the process. We've already applied for grants. We'd need to return the grant money. It would create essentially a bureaucratic nightmare. So we want to make sure that we have this jurisdiction before we move forward with creating this mental health court in the Las Vegas Justice Court. The reason we need a justice court now is because as it currently stands, with only district court having jurisdiction to potentially only having jurisdiction to create mental health court, individuals who commit more serious crimes can enter mental health court. And district court has jurisdiction to accept justice court applicants, but every justice court applicant that goes into the district court program limits the ability of the district court to accept district court applicants. These programs don't have infinite size. So essentially every time justice court were to refer someone to district court, that's a district court seat that we're taking. And that's somebody with a more serious crime who maybe has more serious mental illness that needs supervision, that then can't have that supervision of the district court mental health court. Additionally, our size is growing. Nevada is a fast growing state, and we've determined that based on our growing population, the need exists for a lower court mental health court. Our goal is to treat individuals who are committing misdemeanor crimes before they escalate to committing felony crimes. The goal is early intervention, early deterrence to prevent crime. So the second portion of there's three main things that the statute does. One is establishing the justice court jurisdiction. Second is clarifying who can participate in the program. This is for the sex offender language is for district court participants. Currently, there are two ways to participate in mental health court. One is as a condition of probation or supervised release. In this circumstance, the defendant is adjudicated guilty prior to being placed on probation or admitted to the mental health court. The defendant has a conviction, there's no dismissal of charges, and mental health court is simply an additional requirement of probation, is going through the mental health court program and completing it. Second, pursuant to statute, is as a diversionary program that would defer adjudication and dismiss the case. In this case, the defendant would not be adjudicated prior to entering the mental health court program, and if they successfully complete the mental health court program, they would eventually receive dismissal of their charges. NRS 176A.260 prohibits any participation in the program for Category B sex offenders. So while there's two different ways to participate in the program, because it was the goal to make sure that sex offenders, Category B sex offenders, were not receiving the deferred adjudication or the eventual dismissal of charges, it was the language that was put in was that they couldn't participate at all. However, as just laid out, there's absolutely a way for individuals to participate without receiving that deferred adjudication or without receiving eventual dismissal of charges. Mental health court in that circumstance is just an additional supervision requirement. It actually puts greater requirements on the individual participating. They have closer monitoring, closer supervision, and the court is making sure that they are compliant with their medications, doing everything they need to do. It is a greater level of supervision than simple probation. So what we are seeing is that some sentencing judges who, in circumstances where sometimes there's an agreement between the parties, between the state and the defendant, that an individual is to be placed on probation, or if the judge is deciding to exercise their discretion and give an individual probation, they can place them on probation, but then they can't add that additional layer of supervision and that additional layer of monitoring that comes with placing them in the mental health court if they believe the individual has a mental health issue. So there was some frustration with that essentially Category C, B sex offenders are almost who have mental health issues are being subjected to less restrictions and less monitoring than other types of offenders who have mental health issues. As it says here, NRS 176A.260 does not prevent Category B sex offenders from getting probation. There are multiple Category B sex offenses that are eligible for probation. They're just not eligible for the additional supervision of mental health. So the clarifying language here would clarify that Category B sex offenders do not qualify for deferred adjudication or dismissal. They will be convicted. They will be sex offenders. This is not an attempt to give them leniency. This is an attempt to allow judges to order offenders to complete mental health court as a condition of probation, to have that additional supervision, to make sure that they are receiving the treatment that they need, receiving the medications that they need, and to make sure that they are compliant with their mental health treatment. And I want to add one more thing about this section and this proposal to the bill. Yesterday, the Nevada District Attorneys Association, who is a stakeholder, reached out and let us know that they do have some concerns about this portion of the bill. Specifically, they let us know that one, they're concerned that some of the language could be interpreted as allowing category B sex offenses to be sealed after the completion of mental health court. And two, they have concerns about category B sex offenders being in treatment with individuals who don't commit sex crimes. As to the first concern that they had, I went through and I reviewed the bill and we had a productive conversation. While that wasn't the intention of the bill, and I do think that the bill only seals, and this was pre-existing in the mental health court statute, only seals individuals who receive that deferred adjudication and dismissal. We understand the concerns, and that wasn't the intention of the bill, and we have absolutely no problems adding an amendment that clarifies that category B sex offenders will not have anything sealed, just the same way we added the language about no deferred adjudication and no dismissal. We have no problems with an amendment that clarifies that to address that concern. As to the second concern about intermingling the offenders, we are working with them on that language. We've had some productive conversations. We anticipate continuing to have productive conversations to hopefully alleviate those concerns and see if there's some language that we can work out that would alleviate their concerns. And then the final third thing that the bill changes is the sanction language. Due to the challenges that individuals with drug, alcohol, and mental health disorders face, the National Association of Drug Court Professionals recommends intermediary sanctions for minor violations of court rules prior to escalation to terminate from court programs. Currently, the language of the bill, again, this is clarifying language, the language of the bill, it's ambiguous as to whether for a first minor violation, an individual has to be terminated from the program or whether the court has that jurisdiction to issue intermediary sanctions. So this is just clarifying language that the court does have the jurisdiction for intermediary sanction, and also clarifying language that those intermediary sanctions may include incarceration as a sanction, which is sometimes recommended, and the language clarifies that incarceration should be used as a sanction consistent with evidence-based guidelines from the National Association of Drug Court Professionals. And finally, just addressing the fiscal impact of this bill. This bill does not have a fiscal impact. Nobody is requesting any funding for this. Justice Court has sought independent grant funding. We're not requesting any funding from the legislature. This is purely a bill for clarifying language, to clarify the statutory authority, to clarify whether category B sex offenders can receive mental health treatment, and to clarify that intermediary sanctions are permissible and that incarceration pursuant to evidence-based guidelines is permissible as an intermediary sanction. The goal of this bill is to reduce the cost of incarceration through treatment of mentally ill individuals. Thank you. And that is my presentation in this bill.
Thank you for that, Judge. And I assume you're open for questions?
Yes, absolutely.
Okay. With that, I would like to say that we would appreciate if you did submit that clarifying amendment on those two components. I think that would add more comfort and clarity to everyone. So I'm requesting that you do submit those as conceptual amendments, please.
Absolutely.
Continue.
And I'm sorry. I apologize. This is my first time presenting. As a conceptual amendment, would you like me to present that now or for a work session?
Oh, what it would be is you would just write down, just like those two clarifying bullet points, and submit it to the committee, and we'll have it written up as an amendment.
Okay. Yes, absolutely. We will submit that.
Okay, thanks so much. With that, we do have a few questions. The first one from Assemblywoman Mosca.
Thank you, Chair, and thank you for this. Can you share, is there a backup right now in the district court, mental health court, and how this would help alleviate that?
Right at this moment, I mean, I'll be honest, it ebbs and flows, so I couldn't tell you precisely at this moment whether there's a backup, but yes, historically, we have seen backups in the district court, mental health court. We've had individuals sometimes waiting months in order to enter the district court, mental health court. The judge there has done everything she can, and she's implemented a lot of measures to try to alleviate that. and we've seen some success with it. But the reality is we just have such a growing population here in the state of Nevada, and particularly in Clark County, that we need more.
Thank you. Our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation, Judge. My question is about some existing language, but while I've got you here, I thought I could ask about this. So throughout the bill, but even in Section 1, there's reference to that the program.
Yes, the court does accept individuals who have intellectual disabilities. We do see a fair amount of that in the criminal justice system as well. In fact, just as an example, tying it back to the Category B sex offenses, a Category B sex offense is statutory sexual seduction. If an individual who's 21 years old is having consensual sexual contact with somebody who is 15 years old, what we'll often see is individuals with intellectual disabilities who are on below average in terms of their intellectual functioning will often just hang out with individuals who are younger than them. It's just a natural thing that occurs because their intellectual functioning is lower, so they tend to hang out with people with their intellectual peer groups rather than their physical peer groups. And so that is one thing that we see a lot of, and one thing that the court can address is working with individuals, getting them resources. There are resources that they can be given to help them with their quality of life, helping them. They can even find jobs. There are certain places that they can work. These are all things that can be done, and also just teaching them that, listen, even though you might identify with these individuals more, and that's kind of your understanding level, you can't be hanging out with teenagers. You need to be associating with individuals in your peer group, things of that nature. Yes.
Thank you, Chair.
Thank you. I don't see any other questions from any members. So with that, we can go ahead and open it up for testimony in support. So if there's anyone here in Carson City that would like to come forward, testify in support of Assembly Bill 405. Again, please remember to state your name and spell it so that it's accurate on the record.
Good morning, Madam Chair and members of the committee. Leah Case, Leacase, here today on behalf of the Nevada Psychiatric Association in support of Assembly Bill 405. The Nevada Psychiatric Association strongly supports any programs or resources to help folks who are diagnosed with a mental illness get the treatments, the medications that they need to live a full and healthy life. Thank you.
Thank you, Madam Chair. John Puro from the Clark County Public Defender's Office, and also testifying on behalf of the Washoe County Public Defender's Office. Having a justice court, mental health court would be a great solution for us. There's often times where somebody is accused or convicted of a lesser crime, the misdemeanor, and we don't want to move them up to district court, but there's not a lot of solutions at that justice court level. So this would create that pathway for solutions. When I originally presented to all of the committee at the beginning of a session, I said one of the issues that we have in the state of Nevada is that there's not a lot of front-end care. So a lot of the back-end care for drug abuse and mental health issues actually happens in the court system, unfortunately. Hopefully some point soon we'll move forward to a different model. But for now, this is the model that we've been using in the state of Nevada, and this would provide us with another good tool for that. As far as the sex offense goes, there is no intent in this bill to defer adjudication for those crimes. And there's a way to complete mental health court, and most people do without getting deferred adjudication. Frankly, you have to get the district attorney to even agree to defer adjudication. We call it a straight mental health court plea, where if a client does complete mental health court, that the case will get dismissed. And in my 11 years of practice, I think I've done that 2 times. I've gotten a district attorney to agree to that. Happy to say that both clients completed that program, though. So that is not that often of a thing. The other thing that is of concern is when you have somebody on probation with a sex offense, in the rare occasion, because that does not happen often, it's not something that happens frequently, you have to get the judge to agree. But you also have a staffing hearing where all of the staff, including social workers, court coordinators, everybody involved in the mental health court process has to approve to let that person into the court. And then the court will monitor them. So it's a very stringent program. In fact, mental health court is our most stringent court program where people get the most services and have pretty high success rates. So if we let them in that program, sex offenders that is, they'd get good supervision. They'd be more supervised on probation. So that's something to look out for. But nobody here is trying to get rid of that offense at the end of the completion in the rare event that that person did get probation. They would still be that. And as far as Assemblywoman Cohen's question, we need more robust services for intellectual disability. Sometimes somebody does not have an Access 1 diagnosis, but they do have a severe intellectual disability, and that's impeding their ability to be successful on probation and in the community. And we do not have enough services for those folks. So that's something that perhaps we could address at a later date. Thank you.
Hello, committee. Elise Monroy Marsala, today here on behalf of NAMI, the National Alliance of Mental Illness Nevada. To Mr. Piro's point, Nevada really struggles to provide front-end services to people with mental illness or that are living with mental illness or these diagnoses, and oftentimes these people end up involved with the criminal justice system and with law enforcement. So ensuring that there are services and supports for those people when unfortunately they do become involved with the criminal justice system is something that NAMI supports. NAMI is also working in this building really hard to ensure there are those front end supports, but until we're able to increase access to services and supports like supportive housing or treatment services and treatment options, we need to ensure that folks are able to access supports if and when they get involved with the criminal justice system. So thank you.
Thank you. Is there anyone else here in Carson City that would like to testify in support? Okay, not seeing any. Broadcasting, will you open the lines, please? The phone number is 1-888-475-4499, and the meeting ID for today is 874-6648-8992.
To testify in support to Assembly Bill 405, please press star 9 now to take your place in the queue. There are no callers choosing to testify in support at this time.
Okay, thank you. Then I will open it up for testimony in opposition of Assembly Bill 405.
Good morning, Chair Miller and members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. Although we are at the table in opposition, I want to thank Judge Wood for talking about some of our concerns with us, and hopefully we can work through some of those. We are opposed to the portions of AB 405 that pertain to sex offenders. As written, Section 3, Sub 4B of the bill contemplates including Category B sex offenders in our specialty courts. Now, the judge mentioned statutory sexual seduction, and that is one Category B sexual offense. But I want you to keep in mind these other offenses that are Category B probationable offenses when we're talking about putting these folks in mental health court with other people who may be vulnerable because of mental illness or intellectual disability. The Category B offenses include child abuse involving sexual exploitation pursuant to NRS 200.508, preparation, distribution, or advertisement of child pornography, NRS 200.725, lewdness with a child who is 14 or 15 years old, and this, of course, is any non-penetrative sexual touching of a child in that age group, that's 201.230, possession of child pornography of a child under 16, NRS 200.730, luring a child or a person with mental illness or intellectual disability, NRS 200.300, and sex trafficking of an adult, NRS 201.300. There are instances in which prosecutors have to strike a very imperfect balance by pleading a Category A sex offense to a Category B offense, usually to avoid putting the victim through the further trauma, especially children, that a trial is going to present. And at times, the negotiations do allow the defendant to request probation. But as a matter of principle, we object to the inclusion of these sex offenders in specialty court programs where many of the participants will be particularly vulnerable due to mental illness or intellectual disability. Additionally, I would question whether the nexus between the offender's qualifying diagnosis and the behavior that they've engaged in, especially when it comes to perpetrating offenses against children. The judge did mention, and I appreciate it, on page 6, section 4, subsection 3, that allows for automatic sealing of category B offenses, including those I've just mentioned, after specialty court has been completed as a condition of probation. It's not deferment, it's not dismissal, but it's sealing. And we don't believe that any sex offense should be subject to automatic sealing without the ability of the victim, law enforcement, or prosecutors to object. It's my understanding that that will be amended out of the bill. Thank you.
Good morning, Chair Miller, members of the committee. My name is Beth Schmidt, SCHMIDT, Director of Intergovernmental Services for the Las Vegas Metropolitan Police Department. We are in opposition to SB 405 as written. To be clear, we do support more front-end mental health care. We agree with the NDAA's concerns. Our additional concern is that as the bill is written, the county jails versus NDOC may have to absorb the financial and the manpower costs of incarceration for violators of state parole and probation. We will work with Judge Wood on clarifying why these individuals would not go to NDOC for no more than 25 days.
Good morning, Chair Miller, members of the committee. Greg Herrera for the record, Herrera, representing Nevada Sheriffs and Chiefs. And our position and concerns for AB 405 are in line with the district attorneys and Las Vegas Metro Police Department. Thank you.
With that, is there anyone else in opposition here in Carson City? Okay, broadcasting, is there anyone on the line?
To testify in opposition to Assembly Bill 405, please press star 9 now to take your place in the queue. There are no callers choosing to testify in opposition at this time.
Thank you, broadcasting. Then I will open it up for neutral. If there's anyone here in Carson City that would like to testify in neutral. Not seeing anyone. Broadcasting, is there anyone on the line that would like to testify in neutral?
To testify in neutral to Assembly Bill 405, please press star 9 now to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Okay, thank you. Then with that, I will, Judge Wood, are you still with us?
Yes.
Okay, would you like to make any final remarks?
Yes, please. Thank you. Thank you, Chair Miller. I would just like to conclude by reiterating some of the things that were discussed both by myself and by individuals who testified in support. We need more front-end mental health services in the state of Nevada in order to reduce essentially our cost of incarceration right now. That is why the courts have determined that we need this statute or these amendments to this statute. I would like to just express that I'm actually authorized to express support for this bill on behalf of the Las Vegas Justice Court and on behalf of the Combined Legislative Committee for the 2nd and 8th Judicial District Court. So those are, I think, our 3 largest courts in the state of Nevada all support this bill due to what we are seeing as judges, individuals who come into the courtroom every single day who the primary reason that they are in the justice system is due to their mental health issues. And we believe that it would reduce the impact on the entire state of Nevada if we can get these individuals more services on the front end. And that is where Justice Court is. Justice Court is where misdemeanors originate. And so we want to intercept individuals and provide them services before they are escalating to felonies. I did just want to address a couple of the concerns that were expressed. There has been some conversation about individuals who are admitted to sex offenders being admitted to mental health court and being in contact with vulnerable individuals. To that, I would say that we have a rigorous screening process prior to admitting individuals into mental health court. All individuals who are admitted to mental health court are vulnerable individuals. Even those with serious offenses, if they're being admitted, it's because they've been determined that they are vulnerable individuals with serious mental health issues. I think Mr. Pirro mentioned it, and it is worth repeating. It is not an abundance of individuals with sex offenses who are being admitted into the mental health court. If they are being deemed appropriate, it is a handful of individuals right now with the category C and Ds who are admissible. We're still not just admitting individuals. There's a rigorous screening process, stringent analysis before they are admitted. There's staffing that occurs. There's consideration of the allegations. There's consideration of risk to the other participants. The reason I gave that example about the individual with the intellectual disability, because those are the types of special cases where exceptions are made and individuals are being admitted into the mental health court. There has to be a serious underlying mental health issue before we're admitting individuals. We're not just admitting individuals with depression into mental health court if they have category B sex offenses. That's just not what's occurring. And so the courts believe that this bill is necessary in order to reduce recidivism and address the mental health issues that we have in our community. Thank you.
Thank you so much for that. And with that, I will close the hearing on Assembly Bill 405. Next, before I open the next hearing, I know that we had on the agenda a work session today, but there was an additional amendment that was submitted. So in order to give members time to read and digest that, we're actually going to just roll that work session over to a later day. With that, the second item we have on the agenda is Assembly Bill 380. And so Assembly Bill 380 is presented by Sarah Ralston, and it revises provisions relating to interactive gaming. And I believe that Ms. Ralston is on Zoom right now. Are you with us? There you are. Okay, so Assembly Bill 380 the hearing is officially open. Do you have any co-presenters with you or anyone here in Carson City with you?
I do not.
Okay, so please proceed when you're ready. Thank you.
Great, thank you. Good morning, Chair Miller, members of the committee. My name is Sarah Ralston for the record, and I'm here today to present Assembly Bill 380. Let me start first by thanking Speaker Yeager, who graciously agreed to give me an opportunity to present and discuss this important legislation. I also want to take a moment to give you a little background of me. I am a former business lobbyist in the state, as well as a former executive director to the state's Patient Protection Commission. I resigned my post as the executive director about a year and a half ago to pursue my dream of playing poker full time. I started playing poker 16 years ago, and today I happily sit before you as a professional poker player. Now back to this important legislation. I have prepared some brief remarks, and if it's okay, Chair Miller, I would like to read from this so I don't miss anything. Of course, I would submit it to your committee secretary for inclusion in today's meeting and distribution as necessary. I will also then discuss the concerns with the bill as written and my proposed amendment and allow time for questions at the chair's discretion.
Yes, Ms. Ralston.
I'm sorry, Chair Miller. I can't see you.
Oh.
It's a blue screen on my end. So.
Oh, okay, that makes it a lot more challenging. So yes, that is fine. Even legislators often read off their notes. What we'll be looking for specifically is really for you to walk us through, if you have an amended version, to proceed with that. So not so much the challenges with the current bill, but let us know what you want it to be, what you anticipate it would be after the proposed amendments.
Great, sure. So what I would like to do is talk about the proposed legislation and the intent, and it'll make sense when I then transition into the proposed amendments. I think you should have received it yesterday, but I think I just got a note from broadcasting that you may not have copies with you. But
it's getting posted on Nellis, so we will have it available. Okay. So just please proceed. And I think.
Okay, you got it.
Yeah, it's already there. Yeah, so we're all set. Please proceed.
Okay, great. This proposed legislation relates to interactive gaming in our state, specifically with a focus on creating more transparency for online poker. The main goal of this legislation is to increase transparency in the online poker industry while ensuring that the industry remains protected, safe, and competitive. This protected, safe, fair, and competitive. This proposal will help to maintain Nevada's position as a leader in the gaming industry. To achieve this goal, the legislation proposes one change. It requires online poker operators to publicly disclose the status and names of any accounts with a certain threshold, including accounts that have been banned for cheating or other violations of the site's terms and conditions. This would help to deter cheating and other illicit activities by sending a clear message that such behavior will not be tolerated. This legislation is a significant step forward in ensuring that the online poker industry operates in a transparent, ethical manner while also providing protections for the industry and for the players. This also ensures the state regulations maintain relevance and effectiveness in the face of technological advances and changing consumer preferences. Transparency in online poker is crucial for ensuring the integrity of the game, protecting players' funds, and promoting fair play. Nevada, as one of the few states in the U.S. that has legalized online poker, has a responsibility to ensure that its online poker industry operates with the highest level of transparency. By providing players with more information about who they are playing with can help prevent fraud and collusion, which are ongoing concerns in the online poker community. Overall, more transparency in online poker in Nevada is necessary to ensure a fair and safe playing environment for all participants, and again, to protect the industry at large. There are several reasons why being transparent with the names of accounts that have been banned in online poker is an important policy. One, it's a deterrent effect. By publicly disclosing the names of banned accounts, online poker sites can deter other players from engaging in cheating or other illicit activities. The fear of being caught and publicly exposed can discourage potential wrongdoers from attempting to cheat or violate policies in the first place. Two, restoring trust. When players know that online poker sites are actively monitoring and taking action against illicit activities, it can help restore trust in the online poker ecosystem. This can help to bring back players who may have left due to concerns over game integrity. Three, level the playing field. Banning players for illicit activity helps to create a level playing field for all players. When players know that this behavior is not tolerated and those players are being punished, they can have more confidence that they are playing on a fair and level playing field. Four, protecting players and the industry. By publicizing names, online poker sites can protect players from potential harm, similarly to how disclosing business licensee information is for the protection of consumers and business community in our state. Accountability. Publicly disclosing the names of accounts hold players accountable for their actions. When players know that their actions will be public, it can help discourage them from illicit activities, and it can send a message to other potential players that ill behavior will not be tolerated. In summary, being transparent with the names of accounts, including those that have been banned or suspended in online poker, is an important policy and protection for players and the industry at large. That concludes my remarks on the intent of the legislation. And if okay with you, Chair Miller, I will go into the proposed conceptual amendment.
Yes, please.
Okay, great. I'm hoping I say this lightly because I know that everyone usually tends to say things are simplistic, but I do hope it is my intent to show you that the proposed amendment is quite simple, and it does two things. First, it attempts to address certain privacy and liability concerns of operators by removing the reference to cheating that is on bullet point 1. And it also clarifies that there is no intent to interfere with the Gaming Control Board's excluded persons list and their due process. And that's as simple as that is for the proposed amendment. So with those 3 bullet points, the goal is to accomplish those 2 things that I just mentioned.
Thank you for that. Does that conclude your presentation?
It does conclude my presentation. I promise to keep it within 10 minutes, and I'm thankful for your guys' time and appreciate your indulgence.
Thank you so much. And you did a sensational job with keeping it within 10 minutes. With that, we do have a few questions from members. The first question will be from Assemblyman Gray.
Thank you, Madam Chair. Just a quick question. I really appreciate you're trying to preserve the integrity of the online gaming. However, it is so much different than actually sitting at a poker table in a casino. And, when you blatantly say they've cheated, that would be such a high bar to jump, and then publishing their names and publicly shaming them. I just have a real issue with that. If you want to do it privately, hey, I support that. But just putting those names out there and then along with their birth date, I just have a real hard time with making that information public when it's never been adjudicated, and it's just, I think it opens you up to liability too. I mean, to lawsuits. People see somebody that they may have been playing in a room with that have, been suspended for cheating. Well, okay, they've been cheated as well, not just the casino.
Is there a question there, Assemblyman?
Yeah, sorry. Yeah, how do you propose to address those issues, especially when it comes to a liability lawsuit, by other players?
Thank you so much for the question, Assemblyman. Through you to Chair Miller, through you to the Assemblyman.
Please go direct.
Okay, thank you. Assemblyman Sarah Ralston, for the record, I sincerely appreciate your comment and your concern about that. And I want to say that the proposed amendment is an attempt to address that, right? There is some complexity involved with deeming somebody cheating. And I know that online poker operators have a hard time making that definitive, category. They don't necessarily ban for cheating on their site, on their terms and agreements. So what they do is they usually ban or suspend accounts for illicit activities. Whatever illicit activities those are, up to and including cheating, is what triggers their decision to either suspend account, temporarily suspend account, permanently ban an account. And this proposed conceptual amendment removes that definition of cheating. So there's no burden on the operator to make that determination. Instead, it actually is just asking for more transparency for the poker players and for the industry by having it disclose what the status of accounts are. So that's active accounts, inactive accounts, closed accounts, banned accounts, temporarily suspended, and whichever threshold that operator has. It's just really important to have some level of transparency for poker players. And what I'd like to remind this committee is that this is for real money. This is real dollars. It affects real lives. Poker players have a livelihood that they need to maintain and to protect too. And in like any other industry we see in the state, there is some level of consumer protection. But in the online poker world, we don't have that level of transparency. We don't know who we're playing against or have the ability to have that type of information that's relevant as a player to decide who we want to play with and who we don't want to play with. So again, this is really more about getting some level of transparency and not necessarily to put a definition of cheater, and definitely not to interfere with the Gaming Control Board's process in which they have ban people from casinos on their excluded persons list. You don't want to interfere with any kind of criminal activity. So the intent is really just to have a list of status of the accounts. I hope that answers your question.
Quick follow-on, please.
Proceed.
It does, but it also, brings up another question of complexity. So you want to put everybody that's got an account, and the status of their account, you want to put it on, make it publicly available? So everybody knows, if I'm going out playing poker, online?
Yes, thank you. Thank you so much for the question. The intent is to have that level of transparency. However, so to make it so there are some other business operations and privacy concerns from operators, there is a threshold. So on the conceptual amendment, you will see on bullet point 3, it's requiring only the release of accounts with activity that's greater than $1,000 in deposits or activity in that month. That way, there's more of a delineated list of those that are in this more on the professional side versus on the just amateur side that you want to deposit for $100 or less. There is that threshold there, so you're capturing mainly those that are in this space professionally.
Thank you.
We have a question from Assemblywoman Newby.
Thank you, Madam Chairwoman, and thank you for the bill presentation. How do we know that someone is cheating? Is there a standard? How is that sort of adjudicated and determined that someone is a cheater?
Thank you so much for the question, Assemblywoman Sarah Ralston, for the record. That's one of the reasons why it's important to remove the definition of cheating, but there is abilities for operators and for professional poker players to see patterns. And I'm not sure if Chair Miller wants me to go into a deeper analysis of like the type of cheating that exists online. I think that would be something that operators can share with you. I'm certainly happy to share some, but I don't know if we want to talk about the specificities of cheating.
It's often sometimes a challenge. What we don't want to do is expose any vulnerabilities or present any ideas. So if you want to, it's up to you if you want to briefly describe cheating without giving us instructions on how to cheat. If you know,
I think I can,
you know what I mean.
Thank you so much. Sure. I think what I can do is try to talk about it broadly. But what I look out for as a poker player, and I think in the community at large, is there are a lot of technological advances, especially in the online platform. And so there are so online operators will prohibit the use of HUDs or the use of additional software. That doesn't necessarily mean that they'll catch it all the time or in real time. But for those that want illicit activity, there are softwares that you can download that will theoretically enable you to have real-time assistance while you're playing. So you take away, basically if you're sitting at the poker table, you don't have that, right? And there's a live things. I'm not able to have a computer program with me that tells me exactly what I need to do in certain situations or calculate the hand history of other players. There's also cheating that could happen in both online and in person, in which there's collusion or there's something called ghosting. It's widely known that there are concerns that there are players who are using accounts that are not their accounts. And there's ways that operators, I think, can detect that. It's suspicious activity. It'll likely, in my understanding, get flagged. And then it goes through a due process with the operator and that individual licensee or player. And then I am not sure what the process is, if they've been banned or temporarily banned. That's private. So if something happens from one of the operators and a player has a complaint against it, then they would go through the customer service department of that operator. That's not necessarily regulated by the state.
Follow up, Madam Chairwoman?
Please proceed.
So obviously we've been talking about the online situation where you're playing poker. In the in-person sort of analogous situation, if someone is cheating in a casino in real life, what happens to them? I mean, I know we've talked about the black book, but my understanding is that is very limited in terms of, the activity that you have to do and the process by which you get added to that. So that's very limited. So what happens in real life when someone cheats in a casino?
Thank you so much for the question, Assemblywoman Sarah Ralston, for the record. I believe you're asking me in relation to poker. So I really want to just emphasize the difference between, okay, great, thank you. The difference between poker and gaming. One point of clarification is that the casinos, or I'm sorry, the licensees or operators, they operate in a different manner than any other part of their gaming license in which they're a facilitator. Poker is a skill-based game between peers, so it's player to player, and the operator acts as a facilitator for that game. In person, what typically happens if there is a player who has violated whatever terms that operator has for that poker room, they have a poker manager, floor manager that comes in, assesses the situation, and they make a ruling. They'll make a ruling right then. Usually a player will get a warning, but if after a warning it doesn't change anything, then that operator will decide to ban a player outright or kick him out of a tournament, remove him from the room. And that either happens for the day, for the tournament, or lifetime bans. And that is done individually, privately between each poker room or operator.
Thank you for that. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for answering our questions this morning. So I think I have some similar concerns to my colleagues, especially about privacy, especially with us posting the name and date of birth of every person that is participating in this. And I do have concerns. I think that the analogy to real life poker versus online poker is a good one, because I don't know that when I enter a casino that there's a list of every person that's been kicked out of a poker room as I'm walking into the casino. And it sounds like people are being banned from online. We're just not having a list. So here's my question. What about those individuals who have their account suspended because they put in the wrong information, or because they made some kind of simple mistake that is being investigated and they might be brought back? What happens when they are now listed as banned or suspended, and everyone in the community now knows that, and now there's a big blow up on social media? What kind of protections are those for those individuals?
Thank you so much for the question, Assemblywoman. Sarah Ralston for the record. What I can tell you is, let me give you a scenario in just another business industry, right? As a consumer, I have a right to know if a contractor's license is active, inactive, suspended or not suspended. I may not know why. I don't know why a business license may be shut down, but I can look up and see if a business license is active and there's a historical perspective on it. That is relevant information as a consumer that I have to then decide how I want to proceed in doing business with that business or person or contractor. That's what this bill is proposing to do for the online poker industry. It's intended to provide some level of transparency for poker players. No poker player is going to make accusations out in this world so boldly, because we hold our reputation in such high regard, just like any other industry. And I would say that having that level of transparency, the benefits of having that for protection, not only for players, but for the industry at large, we're the gaming capital of the world, and having the high standards is worth the risk, just like for consumer protection in any other business.
Thank you for that. So understanding that this is about protection then for players, are you proposing that we also create a list of everyone that is banned from in-person poker?
Thank you so much for the question, Assemblywoman Sarah Ralston. For the record, that is not what this legislation is intending to do, although that is actually a great suggestion for the industry at large. This is really related to just interactive gaming and not jurisdiction. Oh, and I'm so sorry. I'd like to go back one more step. In the proposed amendment too, if you can see, Section 2 removes the release of the date of birth of the person's full name and date of birth in Section 2. And so this is really just a necessary first step, and what it's seeking to do is just ask for even just the user account name and the status there too. And so that information is already out there now. I can see active accounts and information based on somebody's username. That is not new. It's not like I can privately go on to a site and not see that person's username. And also when the user is in a tournament and they win, that information is publicly posted too. So there is some level of information that is shared publicly already, and usernames are out there. This is just asking for the other side, right? And an additional level of transparency for account statuses. So I believe your initial concern with the date of birth and the full name is addressed in the conceptual amendment.
Thank you for that. Our next question is from Assemblywoman Hardy.
Thank you, Chair. Good morning. Thank you for being here and presenting this. So just kind of my questions are kind of in line with everyone else's questions. And as I understand this, when a person signs up to play online poker, they register, and then they agree to terms of service, which has, a list of things that they're not allowed to do, et cetera. And so, again, as I understand, these systems are monitored 24/7, and they're looking for illicit activity and such. And then, an account may be banned or suspended for a variety of reasons. And then, so what I'm just curious about is we do have our gaming control board that is over gaming and investigates suspicious and illicit activity and such in all of gaming. And so my question is, where is this public list? Like, is it the Gaming Control Board's publishing this list, or the entity, the establishment? And then, as I understand, any suspicious activity is sent to the Gaming Control Board to investigate, and then they are the ones that are determining the cheating, et cetera. So, like, we have this great oversight in our state currently, and so if you could just help me understand, again, this list, it's public, where is it? And then, I think we have great transparency and oversight in our gaming, so just trying to understand a little bit more of the intent here. Thank you.
Thank you so much for the question, Assemblywoman. I think I understand what you're asking, but point of clarification, there is no list right now. That is what this proposed legislation is seeking to accomplish, is to have a list by the operators requesting that they submit it to the Gaming Commission. This bill outlines or enables the commission to establish regulations on how that list is then published. And so that's to be determined. This is just authorizing legislation for two things. One, requiring the operators submit it to the Gaming Commission, and then the Gaming Commission outlining a regulatory process in which how they're going to distribute or publish that list. The second point, when you talk about, I think, the Gaming Control Board's oversight in general at gaming at large for those that may be put on a cheating list or a banned list, I believe the proper name is the excluded persons list. The intent is not to interfere with that process. In fact, we don't want to interfere with that process. This list may be an additional source of information for the Gaming Commission to consider having a deeper investigation for certain persons, just like they would when they're doing their normal course of review about who should be on that list and who shouldn't, and they have a separate due process for that. And so the intent is to not interfere with that process at all.
Thank you for that. The next question is from Assemblyman Orntlicker.
Thank you, Chair, and thank you for the presentation. And one thing I'm not clear about, I appreciate your removing the release of legal name, full name, and date of birth. That's good for privacy purposes. I'm not clear how that works with your purposes. So now you'll know their game name, what they use, and if they've been banned, obviously you're not going to play with them because they've been banned. what prevents them from going to another site and using another, public name? Since you can't see their full name and their date of birth, how does this avoid that problem? Just hopping from site to site.
Sure. Thank you so much for the question, Assemblyman Sarah Ralston. For the record, I think you're highlighting exactly what we're trying to accomplish is some sort of player protection and oversight. There isn't a way to necessarily know if somebody's hopped over from a site to a site. They could use a different username. It would be better if we had the actual full name attached to it, but I do understand that operators have privacy concerns, and so starting somewhere and having a necessary first step, and so just having it attributed to information that's already out there, just taking it a little bit step further with the status of the account is really the starting point. And so the username, even just having that level of transparency and that information is important for someone like myself, that maybe I'll play a couple of tournaments, but I want to go and I want to enter one of the higher stakes cash games. And usually in a higher stakes cash game, particularly, it's a ring of 6 players. And oftentimes online poker players will play more than one table at a time. And so you're looking at 6, we're playing against 5 other usernames. I should be able to then look at a list and see if that username was ever banned, temporarily banned, suspended, or had any kind of issues with their account. And that gives me a level of information in which I can make a more informed decision about whether I want to play with that particular individual on that particular site. And so that is really helpful. It's just like, do I want to do business with this person? Do I want to play with this person? Where can I check to see if they're in good standing, or they've always been in good standing, right? Because if you start this list, then we will actually have a historical perspective of each username. Theoretically, you're not able to have your account closed and then reopen it, right? Because operators do it by, you wouldn't be able to submit into a new username. So that level of transparency and information is really helpful for poker players online, particularly in some of those higher stake, low ring, as I said. So, and in that case, in tournaments, it's a little bit different because you don't know, you might be playing against thousands of people. It's a little bit harder, but particularly in the cash games, I can see a lot of players finding this very useful, and also as a deterrent for those that are trying to enter into the cash game and have ill intent.
Thank you. Our next question is from Assemblywoman Gallant. Great. Then our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. I was going to ask how important the username is to people, if it's tied to, like with in-person and poker, there's endorsements and things like that. And I'd still be interested in that. But then you were saying that the username someone shouldn't be able to change their username. So I just want to make sure I've got that. So we're not having people going and changing usernames frequently. That's not going to be an issue. So just having their username out there would be enough to help you and other poker players and make sure that there's transparency. Correct?
Yes. Thank you so much for the question, Assemblywoman Sarah Ralston. For the record, that's correct. My understanding, unless an operator allows it privately, but they are not, a poker player is not allowed to change your username. You can use whatever username you like, but you're not able to change it. So if once you sign up to an account, you have a username that is attached to you as a person, and it stays with you.
Okay, thank you. I don't see any additional questions for members, so at this time, I will open it up for testimony in support of Assembly Bill 405. If there's anyone here in Carson City? Not seeing anyone in Carson City. Broadcasting, is there anyone on the lines?
To testify in support to Assembly Bill 380, please press star 9 now to take your place in the queue. There are no callers choosing to testify in support at this time.
Okay, thank you. Then I will go ahead and open it up for testimony in opposition of Assembly Bill 405. If there's anyone, we'll start in Carson City first.
Good morning, Chair Miller and members of the Assembly Committee on Judiciary. For the record, I'm Michael Alonso, and I'm here on behalf of Caesars Entertainment in opposition to AB 380 as written. The proponent did provide us with a copy of the conceptual amendment, and Caesars has looked at it and is opposed to the amendment based on our reading of it. Danielle Barilli is here, who is the Vice President of Caesars Digital and manages WSOP.com, and she will address what Caesars does to keep the online poker environment safe for its customers and its employees. Caesars is currently the only licensed operator of online poker in the state of Nevada that is actively operating a poker site. Caesars operates the site in a heavily regulated environment and works with the Gaming Control Board on a daily basis. Caesars is doing everything it can reasonably do to keep bad actors off the site based on its terms of service. In other words, that bad actor shouldn't be on the site. You shouldn't be playing against them. The proponent is looking for transparency, and on the surface, that's a laudable goal. But Caesars is concerned that the bill as proposed and the proposed amendment may provide actual less transparency than what is there at a very significant cost to Caesars and its customers. Caesars believes that publicly listing its customers will only lead to expensive and burdensome litigation for damaging someone's reputation or from players who think that they lost money to an alleged cheater and want compensation. No licensee, to my knowledge, has ever been required to do this in a brick and mortar or online casino, and we've always had to rely upon the Gaming Control Board to go after bad actors through law enforcement processes, the courts, and where there's due process for those provided to those who are accused of wrongdoing. While we appreciate the attempt to make AB 380 better with the proposed amendment, we believe it's actually worse for Caesars and its customers. The proposed amendment seems to require Caesars to publicly display its entire customer list with account status, so now everyone, including our competitors, can see and use our customer list. We will have to provide publicly and she tried to clarify the names. I'm not sure how that would work, but we have to provide our customers and put them out there with their account status, whether or not they've done anything wrong. We are not aware of any business that's been required by statute to publicly display its customer list for any competitor to see and use. Also, many of our customers want to play online poker and be afforded privacy or anonymity through the use of a screen name, and we don't believe it's good public policy to require a customer to be listed on a public site just for being a customer. And before I turn it over, I just wanted to address maybe some of the questions that were asked about cheating. Cheating is set forth in NRS Chapter 465 already, and that's really with the purview of the Gaming Control Board to determine whether someone is a cheater. We cooperate with them and provide them with whatever information that we are required to provide them with. We provide them with suspicious activity reports, but we don't make that determination. They're a law enforcement agency, and they go through a due process to make sure someone it can be proven that they were cheating, and they can take whatever action that regulators want to take. And again, to the in-person thing, we don't put those things on a list. We're not required to publicly shame anybody when we've 86 them from our property for whatever activity they've done. We do it under our terms of service. And with that, I would like to
Thank you. You may begin your opposition testimony.
Good morning, Chair Miller and the committee. Thank you for your time today. For the record, my name is Danielle Barilli. I'm the Vice President of Online Poker for Caesars Digital. I've been managing WSOP.com since launch in 2013, and maintaining integrity of the game has been of utmost importance. While we do not disclose security protocols, every hand played on WSOP.com is monitored through advanced algorithms in our software and dedicated full-time staff. We flag things like sharing a device with another player, running prohibited software while playing, IP address changes, and physical movements. We monitor gameplay patterns to previous patron history and investigate every accusation made to our customer service. As a private, heavily regulated gaming business, today we are aggressive terminating accounts based on reasonable suspicions to violations of our terms of service. For instance, we've terminated dozens of accounts for repeatedly running Zoom while playing on WSOP.com, even though we could not prove it was used for collusion during gameplay. Should AB 380 proceed, we anticipate being drawn into lawsuits by potentially thousands of players who interacted with a later terminated account and feel retroactively entitled to prize money. We expect lawsuits from terminated accounts trying to clear their name, putting our confidential security controls on public record. For players, we believe transparency is already provided. To establish an account, you need to provide personal information, including a social security number. Players whose accounts are terminated are banned permanently and are unable to establish another account without committing identity fraud. Publishing a list of previously banned players does nothing to generate transparency for today's active customers. Everyone playing on WSOP.com is in good standing. The whole reason we have gaming regulations in Nevada is to protect players, and we think it's working. We have good procedures in place, including regular audits of operations and written correspondence of every suspicious incident. We feel best able to deliver a fair poker game as a private business with the right to refuse service to anyone, absent operational and legal complications that would result from publicly identifying private citizens. AB 380 would be detrimental to game integrity by forcing us to change our approach to protecting the customer to protecting ourselves. Thank you.
Thank you so much for your testimony. Is there anyone else here in Carson City that would like to testify in opposition? Not seeing anyone. Broadcasting, will you open the line?
To testify in opposition to Assembly Bill 380, please press star 9 now to take your place in the queue. There are no callers to testify in opposition at this time.
Okay, then I will open it up for testimony in neutral of Assembly Bill 405. Is there anyone here in Carson City that would like to testify in neutral? Not seeing anyone. Broadcasting, is there anyone on the line that would like to testify in neutral?
To testify in neutral to Assembly Bill 380, please press star 9 now to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Thank you for that, broadcasting. Then with that, Ms. Ralston, are you still with us? Would you like to make
I am.
any, great, would you like to make any closing remarks?
Yes, if I may address a couple of points that was made. First, Sarah Ralston for the record. First, I really want to thank Caesars for coming to the table. As Mr. Alonso indicated, I have shared the conceptual amendment with them prior to the meeting in really making sure that they understand that this is not something, this proposal is not specific to Caesars. I think that they are doing a great job in the space, in the climate and the environment. This is a global issue. This is something that you see worldwide for other sites, but this is something that hits a little bit home for the state of Nevada as a gaming capital of the world, and having the highest standards in that. I also want to make a point to say that when it comes to cheating and referencing, Mr. Alonso indicated that there's a process to that. That's true, but one thing that was omitted was reminding that Caesars in this capacity in their license as an interactive gaming license, it's a peer-to-peer component. It's not a gaming. There is no house element in online poker. They are a facilitator, and it is players playing against each other. They do operate as a facilitator, and I know that they're doing what they can to protect the game, but there are situations where things are of concern, particularly in the tournament space. There was a situation that happened last year on WSOP.com and a $7,777 buy-in for a bracelet event. There were poker players who went in and competed. That is a large amount of money to play. It's highly prestigious. It's very competitive. The person who came runner-up in that situation made an accusation that the person who won played nearly perfect. It was impressive, but there was some allusion to maybe there was some type of assistance. I know that later, about 3 months later, it was publicly reported by that individual who won that his account had been banned. Don't know, but that was for a very prestigious event. That is for a bracelet. This is something that every poker player goes after. It's a piece of hardware and great prize, and WSOP will get an influx of poker players each summer who will go after those bracelets online and different ring events. And even though a player is in good standing at that time, maybe they're not in good standing after review or after that tournament and what happens. And so I will go back to the 2 points of why this bill is so necessary, not only to just, it's the deterrent effect. So having something like this, there will be a deterrent effect for players who have ill intent, and also kind of restoring trust in the community. And so I think it's really important legislation. I really appreciate your indulgence in hearing this. And again, I just want to close by saying the main goal really is to increase transparency in this industry, while also ensuring that the industry at large remains protected, safe, fair, and competitive. So thank you so much for your time today. I really appreciate it. And I'm open to continuing to having a dialogue with Mr. Alonso and any member on the committee, and hope to see this legislation continue to move forward. Thank you so much.
Thank you for that. And with that, I will go ahead and close the hearing on Assembly Bill 405. With that, I'm going to, before we go into public comment, just ask members to just take a pause. So we're just going to pause for a few minutes. Okay, and so with that, we actually are able to bring our bill back onto work session. So we will proceed with our work session for Assembly Bill 340. So members, I know that there was an additional amendment that was passed out earlier, but we are not considering that additional amendment. So the work session will continue as amended in your work session items, with just the First Amendment that has been submitted. So with that, I'm going to ask our analyst, Ms. Thornton, to please walk us through the bill and the amendment.
Thank you, Chair. Diane Thornton for the record, Legislative Council Bureau. Assembly Bill 340 is sponsored by Assemblywoman Summer Armstrong and heard in committee on March 29th. This bill repeals the current summary eviction law and establishes a new procedure for the summary eviction of certain tenants who are not tenants of commercial premises and who default in the payment of rent. There's one amendment to this bill. Assemblywoman Shonda Summers Armstrong and Jonathan Norman from the Nevada Coalition of Legal Service Providers proposed an amendment which revises the bill to refer to calendar days, not judicial days, revises the bill so that it does not apply to commercial premises, eliminates the distinction in procedures between short-term tenancies of 1 week or less and all other tenancies, and makes other revisions to the procedure for summary eviction. And the conceptual amendment is on the following page. Thank you, Chair.
Thank you for that. Members, are there any questions? Okay, not seeing any questions. I would take a motion to amend and do pass. I have a motion from Vice Chair Marzola. Do I have a second? Okay, I have a second from Assemblywoman Mosca. With that, is there any further discussion? Okay, not seeing any. I will take a vote. All those in favor, please say aye. Aye. Anyone opposed? Nay. Okay, so can you just raise your hand so I can make sure we have Assemblywoman Hanson, Assemblywoman Gallant, Assemblyman Urick, Assemblyman Gray, and Assemblywoman Hardy. Thank you for that. And with that, the motion passes. I will go ahead and assign the floor statement to Assemblywoman Summers Armstrong. You're welcome. With that, we will move on to our next item of business, which is public comment. Again, public comment is not to hear any, not to make comment on the bills that we heard today, but to make comment under anything else that's under the purview of this committee. So with that, is there anyone here in Carson City that would like to make public comment? Not seeing anyone. Broadcasting, will you please open the lines?
To provide public comment, please press *9 now to take your place in the queue.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. SB 362 will be heard 4723 in Senate Judiciary. Section 1 of the bill requires a peace officer to ensure that medical aid is rendered to a person who indicates that he or she cannot breathe by an emergency medical attendant, physician's assistant, or registered nurse as soon as practicable. This bill, as currently proposed, would indeed have saved my brother's life, who begged and pleaded for decency from the deputies and officers. He told them multiple times he could not breathe. He told them he had a collapsed lung previously. I appreciate the intent of SB 362 to preserve the sanctity of human life, but would also like to see the word indicate clarified. Indicates how, verbally, with physical motions, with obvious signs like my brother, labored breathing, lips turning blue, and saying he couldn't breathe. I have reached out to the sponsors of the bill, and so has Lenore Dooley, the director of the Medical Civil Rights Act Initiative, in hopes of discussing the bill with the sponsors. We have had no success with getting a response back. I may not live in Nevada, but since the state of Nevada deprived my brother to his right to life, liberty, in the pursuit of happiness, I consider myself a vested stakeholder in what happens in this state. I don't want to see any more deaths, and if the word indicate is not more clearly defined, I fear the foreign, mentally ill, and autistic people will be the martyr with this before anything actually gets done about the wordage. If any one of you can pass on to the sponsors, I would like to have a discussion. It would be appreciated. Let's make the few police accountability bills as strong as possible so that no more unnecessary deaths occur at the hands of law enforcement in Nevada. Whether you want to acknowledge it or not, Nevada has numerous George Floyds of their own, including my brother, at least 10 that I can think of off the top of my head. And please do not support AB 286 or SB 245, which equates to qualified immunity for cops. Thank you.
Thank you so much. Broadcasting, is there anyone else on the line?
There are no other callers to provide public comment at this time.
Okay, thank you. Then I will go ahead and close public comment. And that concludes our business for today. Just want to let everyone know that tomorrow we will not have a meeting in the morning. Instead, we will have a joint hearing with Senate Judiciary at 2 p.m. in room 4100. So again, no morning committee tomorrow, but we will have a joint hearing at 2 p.m. in room 4100. That will be joint with Senate Judiciary as well. And with that, this meeting is adjourned. I will see y'all later.